Thank you very much to our chair, dear Tope, for the introduction. Good evening, ladies and gentlemen. Allow me to start by thanking the organizers, Tope in particular, for the invitation here to address you. In this even more so because I sense that this year she and her colleagues went a little bit out of the box in inviting a Franco-Iranian with colorful cases. I am not just happy to be here, I am extremely happy. Extremely happy because of the distinguished audience, the learned institution. Happy because of the importance and timing of the topic. Happy because I have a direct experience on this topic as arbitrator and counsel, and that I have many things to say, and more importantly, I'm willing to say them. To the extent that I am grateful to be here because I need it, I think, given what I went through, I need it for my own therapy. I propose to divide this presentation into three parts. The first part will be a diagnosis of the origin, nature, and extent of the infringements on democratic values. The second part will give examples of these infringements, and the third and final part will consist in suggesting manners, how the arbitration community can safeguard these democratic values. And each part will consist of 10 points, drawn in part from my direct experience. Part one consists of the diagnosis, 10 observations. The first observation is that in investment and state arbitration in general, and those involving public entities, extraordinary amounts are at stake. We're talking now about billions, sometimes tens of billions, but also important geopolitical issues as reflected in the most recent or ongoing arbitrations. One example are the conflicts that arose out of the war between Russia and Ukraine. You have the Russian state that is being sued for expropriations, and Russian nationals and companies that are suing EU states for alleged expropriations as well. You have the disputes that arose out of the Saudi-led blockade of Qatar that led a number of Qatari companies to engage arbitrations against Egypt, UAE, Saudi Arabia, and other countries. And other example is the Iranian-related arbitrations. Iran's assets, tens of billions of dollars, have been frozen in countries as diverse as Korea and Bahrain as a result of the US and Saudi pressure. And there are a number of arbitration awards that have been rendered and others arbitrations ongoing. That's the first observation. The second observation is that we're at a time of war, protectionism, and a new world order. That means that there are even higher interests at stake beyond the specific issues that arise out of the arbitrations that I just mentioned. The third point is that as a result of all this, the cost-benefit analysis has been impacted. The cost-benefit analysis of going rogue, of crossing the red line, when it comes to violating fundamental rules and values. In other words, today, it's worth it, because of all these, to go rogue, or at least to consider going rogue. The fourth observation is that this is occurring in every sector. as reflected, for example, in the manner that war is conducted from all parties. Civilians are not spared, women are not spared, children are not spared, and sometimes heads of states are no longer spared, but directly targeted. The fifth point is that democratic values and arbitration are no exception. There are no exception. Red lines are being crossed when it comes to compliance with democratic values, including fundamental rules of law and the principle of deference to certain functions. Six, amongst these principles and functions impacted are the freedom of thought, the freedom of expression, civil liberties, the respect for human rights, including the dignity of individuals, freedom of movement, freedom of travel, access to justice, a fair trial, right of defense, equality and non-discrimination, due process, protection against arbitrariness, protection against collective punishment, deference to the adjudicative functions, such as those of the arbitrator or judge, deference to the rights and obligation of counsel towards the client, towards the judge, towards the arbitrator, towards the whole judicial system. 7, there is a slippage in these values driven by the sovereign states at the highest level. 8, these transgressions are today occurring at the hands of both Western and emerging states and parties. 9, the situation, I believe, that's my assessment, is worsening with each day that passes. Gloves are off. There is no de-escalation, but rather overbidding. And 10, there is a banalization of the process, and even worse, sometimes with the complicity of actors in our field, passively or actively. Now, I move to my second part, which are examples of these diagnoses and the observations that I have just made. And I will give you examples running from 2021 until last week, 2025. And these examples are different than the war stories that we all have and marginal occurrences due to marginal characters in certain areas of the world, which we all have witnessed. Because there always have been infringements, but they have been isolated or marginal. One example, if you recall, those that follow investment arbitration, it was the Republic of Turkey that put under surveillance the claimant and counsel, a prominent US firm, in an illicit arbitration against Turkey. And they were caught and severely sanctioned. And we all have examples of nasty parties or representatives of the parties that harass tribunal members, file criminal suits based on nonsense to intimidate and derail the process. I recall, I think the most telling example was a chap from United Emirates. He used to write to me and my colleague on the panel every week or so to insult us, to provoke us, to say that they, and sometimes I missed it. There was some week he wrote a few times, but it was clear that the process, the objective was strategic to just delay and avoid denial of justice. But what I want to cover through the 10 examples is something completely different. It's more of a beginning of a trend. It's institutionalized and involves Western transgressors with a significant impact. I will start with example 1, and it's an example of my partner. It dates from 2021. Yves Doras, former Secretary General, is of certain age, experience, as a chair of a tribunal of a case ICC case, Commission Import-Export versus Republic of Congo, he issued an award ordering Republic of Congo to pay a very large amount, which with interest now is above $1 billion. And the award creditor in 2021 tried to enforce the award in France against the assets of the Republic of Congo. And while the award creditor was doing that, the Republic of Congo came up with an allegation of corruption against my partner, filed a criminal lawsuit and an action for revision of the award, and used the same to try to block the seizure of its assets. Based on what? Because we said there has always been allegations and intimidation of arbitrators, but this time it was a milestone that was reached. Why? Because it was based on an affidavit of a US attorney alleging, was not Russian, was not Iranian, was not African from Latin America, US attorney alleging, based on a conversation he had with someone that he did not identify, that that person had given my partner a Rolex watch and promised him in exchange of the award to give him a percentage of the proceeds, not of the award, but the award subject to it to be collected, hence the link he made to block the enforcement. And based on that, the specialized press, GAR, and others reported that. It was echoed also in the mass media, and there was a significant impact personally and on the activity of my partner. The revision application was ultimately dismissed, but after 2 years, and after all the emotional and professional hardship. That's the first example, an unprecedented attack on the adjudicative function and the dignity of a prominent practitioner. Second, as of 2002, because of the aggravation of the conflict between Russia and Ukraine, a number of nationals and companies from Russia were sanctioned in Europe and in North America. Now, each case is different, but there are allegations, cross allegations, that some of these sanctions, depending again on each case, have been in violation of fundamental principles that our ancestors have established, such as due process, protection against collective punishment, or compliance with norms of proportionality. Third example is that from that time onwards, it has been very difficult for certain states, for certain nationals of certain states and companies to access to justice or to have an even field playing defense. Why? Because experts, lawyers, arbitrators, sometimes in the Iranian cases, they need an OFAC license. So they don't apply, or they are not instructed to apply because it takes a long time. Sometimes they do apply, they don't receive it. And in very limited cases, they receive it. Or because other practical impediments, such as inability for these parties to pay their lawyers, their experts. And the odd thing is that even Western companies want the other party to access justice. We had a conference last week or 2 weeks ago in Paris, and the Western company said, we want the other party to access to justice. We want this to be promptly done. We want also to them to have banking channel, otherwise we have to pay substitute payment for the respondent party. Also, we want it to be prompt because we don't want to wait in line for enforcement, such as, for example, wars against Venezuela, where many maybe are waiting in line. Plus, we want them to have a right of defense because tomorrow We don't want them to block enforcement because of due process violations. Even some of my clients, which are respondent Western companies involved in sanction cases, they want the case to go on so as to close the case and avoid countermeasures or finding themselves in a litigation because these clauses are declared ineffective. Plus, there is social pressure. Social pressure. Lawyers, arbitrators face shame in accepting certain cases. The heads is down, they hide, or they refuse cases. I can give you an example which traumatized me. In 2022, I received a request from a Russian state to act in one capacity. My assistant automatically forwards it to a conflict check. Then I have a lineup in my office when I come with my junior partners and associates. What the hell are you doing? You should not even entertain the possibility of playing any role in a case involving Russia. And that case didn't even involve Ukraine. It was an investment case that had strictly nothing to do with Ukraine, just that the counsels and arbitrators in that case, because of the social pressure, because of the movement, had stepped down. And I told the gathering in front of my office, I said, come on, sit down. Have you read about the case? Have you read about the conflict? Do you know anything about the conflict except what you may hear in the newspapers? Have you read the perspective of other newspapers in Latin America, in Asia, in the Middle East? Do you know the arguments that are being raised by the opposing side? They say, no, but it's not worth even looking at it. It's a country that has invaded others. I said, but you should at least know the arguments to better dismiss them, as if their freedom of thought had disappeared. Plus, then we did another round. I said, okay, let's pass this question. Tell me, assuming that party, in that case, it would constitute representing the devil. Assuming it's not even arbitrator, assuming it's counsel. What do you do to other fundamental principles? Right of defense, right to a fair trial, access to justice. Have you considered these and the long-term impact that it would escalate the conflict if others do not have access to justice? I said, let's go one step beyond. I said, a couple of months ago, we were representing the Republic of Sudan. We were at one of the presidential palaces having dinner. It was at the time of al-Bashir. He was wanted by the criminal court for genocide, for war crimes. Did it cross your mind to say, okay, what the hell are we doing? This is even maybe worse. So the social pressure is such that certain parties, national, states, companies of certain region do not have access to justice. Example 4. On February 2024, I applied for a visa to go where? As a French national. I applied for a visa to go to the United States as a French national, not as a tourist, but as part of my adjudicative function as an arbitrator in an ICC case. Why do I need a visa to go to the US with a French passport? Because I traveled to Sudan and Iran, and any EU citizen that has traveled to Iran or Sudan needs to apply for a visa. I have a letter for the Secretary General of the ICC, reference of the case. It has nothing to do with any sanctioned countries. It's Latin America, North America dispute. A number of questions that are asked to me that I think are borderline on infringement of my confidentiality obligations and my civil rights. But I answer. My relationship with certain people, my telephone numbers, all the telephone numbers that I've used over the last 5 years. Every location I went, not every city I went, every location I went in every city that I visited over the last 5 years, plus a large number of other questions, I answered. I can understand. They told me, wait, we will revert to you. Said the hearing is in a month. I said, we will revert to you. I'm still waiting for them to revert. A year has passed. A year has passed. Again, I'm not going there as a tourist. That's an infringement. It's a violation of the deference to someone that settles disputes, an arbitrator. It's offensive to the ICC. It's offensive to the counsels that have selected me. It's offensive to the prompt resolution of the dispute. So we moved the hearing. The parties were kind enough to do that. Fifth example, in 2024, another milestone, OFAC announced, have you seen the OFAC list of sanctioned parties? It's a full-time job I don't know who else is there to put in this. Now they announced OFAC, 275 individuals more in 17 jurisdictions. Why is it particular, this one? Because they added 2 Swiss lawyers for having moved funds, Russian funds, through shell companies. They said for exploiting a loophole in Swiss law. So it's not a violation of a international law, Swiss law, but exploiting a loophole in Swiss law. So you have Swiss attorneys now. Sixth example, October 2024. The Council of the EU, followed later by the UK, enacted on companies such as Iran Air, the national Iranian airline, sanctions. Basically, Iran Air stopped all flights in Europe. Based on what? Allegation that Iran is assisting Ukraine Russia in its war against Ukraine. In that case, I have sufficient, as I mentioned, it's case by case, but in this one, there was no little due process. There was no little consideration of the principle of prohibition against collective punishment. There was no limited respect for proportionality. And you know what? Decision makers know it in that particular case. They know it, and they also know that it's going to get eventually overturned, as some of these were overturned by the European Court of Justice. But they say it's politically driven, and it will meet the objectives pending review. And if it doesn't, then we will come back and use another pretext. But with what impact on these principles? What long-term impact in terms of peaceful resolution of conflicts? Seventh example, it's in late 2024, and it was implemented, I think, in February 6, 2025, if I'm not mistaken, yes. It's US executive orders putting officials and agents of the International Criminal Court on the sanction list, including immediate family members, and freezing the assets of the prosecutor. Is that proportionality? Is that fair due process? The family members, what they have to do in this? Agents, employees, personnel. 8, early 2025. This one I'm going to spend a little time on, but I have to be cautious because there is this camera. I was in an emerging country, for which I have a lot of affection. Emerging countries where I have a lot of activities, cultural, academic, professional. And I went there, and someone was a member of my staff when I go to this country and does everything for me, passed me his phone. So somebody wants to speak to you, and it happens sometimes that people call on his mobile because it's a local number. I said, hello. He said, how are you doing? I was not in the capital of that country. How are you in that city? I hope we're not inconveniencing you. I said, please go ahead, proceed. I cannot recognize the voice. Who are you? Very cordial. He said, I'm an intelligence officer, and I apologize to contact you, but we want to meet you tomorrow at a certain time in the capital of the country to host you, to get to know you in person, and to ask you a few questions. Okay, so I went to the capital. I had no choice. What do you want to do? I go there. You have no phones. You can't bring phones. You can't bring files. You go. Very polite. It's an official building for intelligence. You go. No windows in the room. 3 gentlemen. Fruits. Tea, coffee. Very polite. The roles you can anticipate immediately. You had the good, the bad, and the ugly. They ask you why you don't want to. They serve you fruit and sweets. So you say, why aren't you eating? Would you eat there? So it was fun actually. I said, why don't you eat it yourself first? Yeah, a lot of compliments. We heard about you. You did these cases, and you helped our sovereign state in different ways. We appreciate it. It's okay, you didn't bring me to tell me all this. I said, no, but you have one case as counsel that is bothering us, and you should not have said this, and that, involving not even an official public entity of that state, but a quasi-public entity. And what is relevant, why am I saying that, is first, you tell yourself, because when they're speaking to you, the three of them, you say to yourself, what the hell are you doing? So you have things that go in your mind, your chalet in the ski resort, your family, your friends, that you could have been there. What the hell are you doing here? Why did you come? And then the ideas unfold, and 2 are relevant to you. One is that I thought of the case where I was acting as counsel, and I say, I better not report this if I get out, because I like this country. I don't want to escalate, and it's going to make it worse. It's not good for me, nor that country. I will resolve it in another way. Plus, I thought that the tribunal didn't have the backbone. Didn't have the backbone to do anything about it. And I'll get to this point later. While I was talking to them, this was going in my mind. And third, as I was sitting there, I tried to calm myself before taking the floor. I tried to calm myself because I had no choice. You have to remain calm. And second, more importantly, because I said to myself, if the same facts arose in the United States or in Europe, I'm not sure the intelligence services would have acted differently in certain states. That's the sad part. That is the sad part. And I was right. I was right. You know why? Because a few weeks later, executive order of the US presidential office, President Trump, that sanctioned law firms. Law firms. Covington Burling. Let's look. Accused of involvement in the weaponization of the government by providing free legal services to former special counsel Jack Smith, who led a political charge investigation into Donald Trump. Also for motivated misuse of prosecutorial power aimed at undermining the democratic process. What's the sanction? Review and potential termination of all federal contracts with the firm and assessment of alignment with the administration policy. Also, WilmerHale, another prominent law firm, pro bono practice. Okay, they obtained a restraining order, but look, pro bono practice to advance partisan political agendas, obstructing immigration enforcement. Also, this Robert Mueller, hiring him after his investigation of the Russian interference. And what are the sanctions? Restricted access for WilmerHale employees to federal buildings, prohibition on hiring of WilmerHale employees in federal agencies. That would make the people that interrogated me in that emerging country blush. Blush. 10 last week, my Russia. I don't know now. I'm an arbitrator in a case, a ECT case that was reported in the press last week. I was appointed by Russia, and one morning, it was April 17th, I get up, look at my emails, the Russian press say you have been sued with counsel as arbitrator by the Russian prosecutor. What is this? I mean, we have to verify because we don't know. It has been reported in the GA, so I cannot speak other than to say that that's the information in the public, and it has to be checked whether it's true or not. If it's true, that's another step backwards, another level of, I don't know how to qualify it. Why? Because normally you're sued by someone when you did something, you issued something, right? Here it's the outset of the process. Plus they appointed me. They call you, they say, "We appoint you. Thank you for accepting. It's access to justice. We appreciate. Thank you. Run a conflict. You accept and they sue you." But why not? Why not? It's the next step. Everybody is overbidding. Even my wife, she said, "Why are you upset this morning?" I said, "It's reported that Russia may have sued me." Even for her, so okay, so what are we going to do this morning? So, and usually when these happens, you get like 30, 40 emails of friends that call you. Nobody even calls you now because it became normal. So these are the examples. Now, very quickly, what measures to safeguard our values? I think the first thing is that we all have to be conscious that arbitration is one of the bastions, one of the few bastions against infringements on our values. That it is a safeguard and a efficient means for peaceful resolution, binding peaceful resolution, impartial, independent resolution of international conflict. And a safeguard for the application of all these values that our ancestors have established over the years. If we take conscience of that, then we have to exercise our responsibility. And I don't think many realize this, and I don't think a lot of people have the backbone. Remember I said I'll come back to the backbone? I don't think so. Our predecessors did establish these values. They also boosted arbitration, landmark conventions, Exit Convention, New York Convention. They made such efforts and comprehensive engagements that led to many nations accepting, all the nations accepting arbitration. What did our generation do? Of course, great writings. We have the Redfern schedule, we have the Stern schedule. But what else? What else? We take advantage of the system. We're afraid to engage. We don't even think about engagement. And when we do, we say, okay, but it's going to be risky. I may lose this nominations. I'm going to look bad. I'm going to have problems, or I don't have the time. I better focus on other things. I think we've reached a stage that has to stop and evolve towards taking responsibility and each of us doing our share. Second measure is that tribunals should be very strict in applying principles of international law. Due process, again, proportionality, no collective punishment, access to justice, even playing field. And 3, tribunals have to call a spade a spade. That is important. They should not just say it's a violation of international law. In certain circumstances, they have to spell it out for all the parties, including for the wrongdoer. I'll give you one example. Iranian assets were expropriated in Bahrain as a result of the Saudi pressure on Bahrain and the overall conflict that existed at the time between Iran and Saudi. We started an arbitration for Mankemeli and Sadarat, and it was the tribunal at the end. It was Professor Gaillard who passed away. There is Professor Dalzer who also passed away. At the end, we had Gabriel Kaufmann-Kohler, Rhodes Collins of Mavesbury on the tribunal, and Bernard Anocchio. And in writings and at the hearing, I said, you have to call a spade a spade. Don't say you just violated Bahrain international law. Say it was a politically driven expropriation at the hands of the Saudi Arabia. And the tribunal followed suit. And they had particular sections on this saying Bahrain violated international law in a context of a political feud between Saudi Arabia to which policies it adheres. And it was a political driven expropriation. That is good for Bahrain. It is good for Saudi Arabia so that they know they get caught and history records what they're doing, but it's also very good for Iran in the future because it encourages Iran to resort to peaceful dispute resolution mechanism and not think, at least for these type of disputes, to other means. 4th, arbitral institutions should allow access to justice, and LCIA and the ICC have finally managed to do that by obtaining licenses and by other measures such as allowing counsels to make the payments for the advance on cost. But I think also the parties should consider, even if there is a clause with a particular institution that cannot promptly process the arbitration, other institutions in the world, including ISTAC in Istanbul, that can proceed promptly and fairly with these arbitrations. 5th, institutions and also arbitrators adding ad hoc should facilitate payment by alternative means. PCA, for example, with ISTAC now accepts Chinese yuan, maybe tomorrow cryptocurrency. And I think that is important. Why? For access to justice, fair trial, to avoid then others being tempted by countermeasures, by rogue conduct, and also for the policymakers, those that engage in rogue conduct, to say, okay, at the end of the day, in these arbitrations, like the one I said, Mankemeli versus Bahrain, by the way, the award got upheld yesterday on annulment in Netherlands, these countries would know that, okay, you get caught, you have to pay, their awards are enforced. Plus, if you do this, there are currencies from other emerging countries that are progressively going to replace your currency. It was inconceivable to have payments in Chinese yuan accepted 10 years ago. Now, 6th measure is that to lift practical impediments and social pressure for experts, arbitrators, and counsel to act in arbitrations. I think that is the very basic notion that we should all share: access to justice, fair trial, right of defense. 7, for the same reasons, we should opt for the seat of arbitrations where even playing field is offered. I mean, it's hell to get visas for certain nationals. It's hell to get visas, then to come also, for example, to Paris, not to have a credit card because the SWIFT is blocked. And in countries like the Republic of Turkey, you can pay in alternative means. You can pay in cash your hotel. You don't need visa. And also you have a direct flights. They took the direct flights from Russia to come to the Europe, or for Iranians. So alternative forums for purposes of access to justice should be considered. 8, also tribunals, at least in sanction-related cases, should choose in cases where the seat has not been contractually chosen or is not in the BIT, venues located in countries when sanction dispute is involved that have not enacted the sanctions that are being challenged on the basis of international law. Because then if the sanctioned party wins or loses, then it ends up in annulment proceedings before that court. And I think there is a case made by nationals, companies, or of sanctioned states and states that would be the red line. 9, reinforce immunity of arbitrators in line with the OHADA Convention, Article 21 of the ICSID Convention, to provide for absolute immunity, subject, of course, to certain exceptions. And 10, and last, I would say, provide a fast-track process to hear challenges that are the type of corruption allegation that my partner faced on a fast-track basis, including during the revision process, so it doesn't take 2 years, to preserve confidentiality, to sanction breach of confidentiality, and also sanction by the word of mouth every counsel or person that jeopardizes the integrity of the process in one way or another, including by echoing nonsense that undermine our function as arbitrator and counsel. Thank you very much for this opportunity and your attention.